All right, let's get you ready for your CA Foundation exams. Today, we're diving into Unit 1 of the Sale of Goods Act, 1930. We're going to break down everything you absolutely need to know.
So think about this for a second. What's the real legal difference between buying a coffee right now versus agreeing to buy a farmer's entire coffee bean crop for next year? It sounds simple, right? But that difference is everything in contract law, and it's the heart of what we're tackling today. Let's get into it.
Okay, here's our game plan. We'll kick things off with the absolute essentials of the Act. Then, we'll get into some key terms you gotta know. After that, we'll look at how goods are classified, which leads us to the big one, sale versus agreement to sell. We'll also see how a sale differs from other contracts, and finally, we'll wrap it all up with the key takeaways you can take straight to your exam.
First up, the essentials. Think of this as the foundation for everything else. We need to be crystal clear on what this act actually covers and what it doesn't.
And here's the first big rule, probably the most important one. The Sale of Goods Act only deals with movable property. We're talking about things you can physically move, cars, phones, even growing crops. It does not apply to immovable property like land or buildings. That's a whole different law. So remember, if it's stuck to the ground, this act doesn't touch it.
All right, let's build up your exam vocabulary. Getting these key terms right is a game changer, especially for those descriptive questions where every mark counts.
First up, buyer and seller. Seems obvious, right? But look closely at the wording. It's not just someone who buys or sells, but also someone who agrees to buy or sell. That little phrase, agrees to, is huge, and it's a theme we're going to see again and again.
Now for the big one, goods. This definition is the bedrock of the entire act. It covers every kind of movable property, but then it throws in two really important exceptions. So let's see what's in and what's out. So what counts as goods? Well, it's a pretty wide net. You've got the obvious stuff like stocks and growing crops, but it also includes intangible things like goodwill or patents. What's crucial for your exam is knowing what's excluded. Actionable claims like a debt someone owes you and money in circulation are not considered goods under this act. Memorize those two exclusions.
Okay, let's talk about delivery. You might think it just means handing something over, but the law is a bit more sophisticated than that. It's all about the voluntary transfer of possession, and there are actually three ways this can happen.
First, there's actual delivery, this simple physical handover. Easy enough. Then you have constructive delivery. This is a bit more abstract. It's when a third party, say a warehouse keeper who's holding the goods, acknowledges that they're now holding them for the buyer. No goods physically move, but possession has legally changed hands. And finally, symbolic delivery. Think of this as handing over the control of the goods. A classic exam question is handing over the keys to a car or a warehouse. The key represents the goods.
So we know what goods are, but not all goods are created equal, at least not in the eyes of the law. Let's get more specific and look at how they're classified. This is super important.
It all boils down to one simple question. Do the goods actually exist, and does the seller have them when the contract is made? Based on that, we get three main types: existing, future, and contingent goods.
Okay, let's zoom in on existing goods first, because they have their own subcategories. Specific goods are the easiest. They're identified right at the start. For example, I'm selling you this specific car with this registration number. In contrast, unascertained goods are defined by description only. Like, I'll sell you 50 bales of cotton from my warehouse, which has 100 bales. Which 50? We don't know yet. The moment you pick out those specific 50 bales and set them aside for the buyer, they become ascertained.
Then we have future goods. This is pretty straightforward. These are goods that the seller has to manufacture or acquire after making the contract. So if a farmer agrees to sell you all the wheat he's going to grow in his field next season, that wheat is future goods. It literally doesn't exist yet.
Okay, everyone, listen up. This next part is arguably the most important section in this entire unit. It's a guaranteed favorite for exam questions. If you understand the difference between a sale and an agreement to sell, you are well on your way.
Here's the core distinction in a nutshell. In a sale, ownership, the legal property in the goods, transfers from the seller to the buyer immediately. Boom, it's done. But in an agreement to sell, that transfer of ownership is pushed to a future date or happens only when some condition is met. Think of it this way. A sale is a done deal. An agreement to sell is a promise of a future deal. And this difference has massive real-world consequences, which this table lays out perfectly. You've got the nature of the contract, the remedies for a breach, but for problem-based questions in your exam, zero in on burden of risk.
This is the golden rule you need to tattoo on your brain. Risk follows ownership. Whoever legally owns the goods at any given moment is the one who bears the loss if they get destroyed.
So let's apply that rule. X agrees to sell his car to Y next month. If that car is destroyed by a fire today, who's out of luck? Well, this is an agreement to sell, because the transfer is in the future. Ownership hasn't passed to Y yet, it's still with X. So, since risk follows ownership, the risk is still with the seller, X. He bears the loss.
Awesome. Now that you've got the core concept down, let's quickly make sure you don't get tripped up by similar-looking contracts. These distinctions are perfect for case studies.
First, sale versus hire purchase. This is the common point of confusion. In a sale, ownership passes right away. In a hire purchase, the person hiring the goods has the option to buy them at the end, usually by making the last payment. They are not obligated to buy. Until that final payment, ownership stays with the original seller, and the hirer is just a bailee. They have possession, not ownership. Next up, sale versus bailment. This one's pretty clear-cut. Bailment is all about transferring possession, not ownership, for a specific purpose. Think about giving your clothes to a dry cleaner. You're giving them possession, but you fully expect to get those exact same clothes back. In a sale, the whole point is that you're transferring ownership forever. The goods don't come back. All right, we've covered a lot of ground, so let's distill it all down to the absolute must-know points for your exam. This is your final revision checklist.
Here it is, your exam checklist. 1. The act is only for movable goods. 2. A sale means ownership and risk transfer immediately. 3. An agreement to sell means they transfer later. 4. The golden rule, risk follows ownership. And 5. Know the clear differences between a sale, a hire purchase, and a bailment. Seriously, if you can explain these 5 points, you are in fantastic shape for this unit. Okay, to leave you with the final brain teaser, let's say a farmer agrees to sell you 100 tons of tomatoes to be grown on his land. That's a contract for future goods, right? But what if a crop disease hits and he only produces 80 tons? Is the contract void? Think about what we've discussed. Future goods, perishing of goods. How would you tackle that? Keep working on problems like this. You've got this. Best of luck with your preparation.